All right. We'll get started. Good afternoon, everyone. Welcome to the series Mud Talks. My name is Erin McNabb. I'm the Associate Director in the Office of Alumni and Parent Relations and proud member of the class of 2006. We thank you for attending today's event, and we hope you and your family are safe and healthy during this time. This talk is being recorded, and we will distribute the video link and any of the presentation materials after the event. Please feel free to type your questions in the Q&A box, and we'll try to get through as many as we can throughout the presentation and after. Now, to briefly introduce our speaker, Raul Martinez, class of 97, studied engineering at Harvey College and received his law degree from the University of Utah in 2000. After working as an attorney for over 15 years, he decided to open his own law firm in 2019 to help clients in a more meaningful and direct manner. Martinez's firm specializes in domestic and foreign patent prosecution, patentability, and infringement opinions. Take it away, Raul.
Thank you, Erin. I appreciate it. Let me start sharing the screen here. Okay. All right. So one of the preliminary questions that Erin told me that was asked was, how did I, as an engineering student, get into law? And it just happened to be that my sophomore year, one of my suite mates, who was a senior at the time, decided he was going to go to law school. And that kind of started the ball rolling, and I started exploring more, and I'm glad I did. So now, just to give you a brief summary, we're going to go very fast. There's a lot to cover, and I will not be able to answer all of your questions to the extent I would like to. I'm a talker, and so if I gave you all the detail and everything that I wanted to discuss today, it would probably take 2.5 hours, but we have a short period of time. So I created this presentation as more of a takeaway. So hopefully, at least we will help you spot some issues, spot some things that as potential founders of companies, that you don't know what you don't know, right? And so there's a lot that goes into creating a intellectual property strategy for your company. Not everything in the presentation today is directly related to intellectual property, but at least tangentially touches upon it. And so I just wanted to give you guys a brief overview. And so whichever portions speak to you that you feel you need to learn more about, you can investigate them, research them on your own, or find an experienced attorney that has a focus in those areas where you have further questions. As Erin mentioned, my specialty, my focus is mostly on patents, with about maybe 1/4 to 1/3 of my practice is on trademark. So everything else I'm going to talk to you about today still is very high level and isn't necessarily my specialty outside of those two topics. So let's get going. Okay, so we're going to talk about general considerations just overall when it comes to IP strategy. We're going to talk about who owns the IP, different types of IP, website, app, and operations, and data security. Again, very quickly, we're just going to touch on these one at a time, and hopefully we'll have some time for a Q&A at the end. Most importantly of all is to match your IP strategy to your business strategy, your business plan, and the technology. You know, what sandbox do you play in? Because not everything that we're going to talk about today is going to be applicable to every single startup, right? I think the one thing that will probably touch everybody is trademark, right? Because you have to have branding, you have to have a company name, maybe a logo or a slogan. But outside of that, maybe not everything else is going to be applicable to you. So don't feel overwhelmed. And also don't feel like you have to do everything before you get started, right? Some of these things you can check off as you go, as they become important. Others of them you can let simmer in the background until you have more money or until the time is right. But it's good to have an idea of these different ideas and concepts so that you can match your strategy to executing these in a timely manner. Again, short-term, medium-term, long-term goals for your IP should also match those same timelines for your business plan. And I like to look at your IP as an investment, right? I don't like people to look at it as just a necessary evil, because if you do it the right way, hopefully you're maximizing that ROI on those investment dollars. You know, you're creating barriers to entry where you can have the ability to preclude other people from exercising, being able to make or use products that cover claims of maybe or to trade off your goodwill in the sense of a trademark, right? And again, as the bullet point says, focus your IP budget on areas where you derive the most profit. Whichever are the features of your product that drive sales for you, that's really where you should focus your IP dollars. But also not only on the feature of the product, but also on geography. If you only generate maybe 10% of your revenue in foreign countries, you definitely don't spend 50% of your IP dollars there. It doesn't make sense. So you have to match those things up and make sure it makes sense. Now, who owns it? It's very important that you have agreements up front with the founders of who owns the IP, who's contributing what. Does it belong to them? Does it belong to the company? If they have a falling out, who gets to keep the IP? So these are all things that are important to keep in mind. Same thing with employees. Your employment agreements should indicate they're going to be exposed to proprietary information. They're hopefully going to create some proprietary information, and that everything that they create that has to do with your business is assigned to the company. And make sure you explicitly indicate patents, trade secrets, trademarks, copyright. Sometimes people forget that when you have software developers, they're writing code, and that source code is copyrightable, and make sure that they assign that to the company. Now, also an employee handbook, make sure that whoever's coming in, you know, you're super excited to hire someone who has great experience, but if they come in and they bring with them IP, that opens you up to potential lawsuits in the future. So you have to make sure that very clearly, explicitly indicate they're not supposed to do that. Bring their skill level, their expertise, but definitely not anyone else's IP. And also at the end, you have to look forward and say, listen, okay, once you've been here and you've been exposed to our IP, you've helped create things, you might have residual data IP on your personal devices, or hopefully not, but it's possible. And what are the expectations when it comes to your departure or termination? Independent contractors. Now, this is a whole another thing. We're not going to get into the weeds on this, but I understand it makes sense to, you don't have the necessarily ability as a startup to hire full-time employees, maybe not a lot of them. So you might hire independent contractors to do work for you. Now, the problem with that though, is that if you make their independent contractor status a work for hire, especially in California, you just made that person a statutory employee. And therefore you have to comply with all the labor laws, workers' comp, unemployment insurance, et cetera, et cetera. Now the alternative to that is don't make it a work for hire, but that independent contractor who's an individual now still has copyright authorship of that work, whatever they created for you. And so you have a non-exclusive license to use what they created for you, but they still have ownership rights, which can create a lot of problems. So one way around that is to just comply with the labor laws, make it a work for hire, and then you comply with the workers' comp, unemployment insurance, and so on and so forth. But now this doesn't apply to corporate contractors, but you have to ensure that they have their proper agreements in place with their employees or any subcontractors. And of course, that gets even more complicated with offshore vendors. You have those agreements be very clear on when you're licensing IP out. How is that IP going to be treated? How is it going to be protected? And same thing when you're incoming. If you license someone else's technology, you have to make sure your employees handle that IP properly so it doesn't get misappropriated or misused. All right, different types. So patents, you know, anything that's a new, useful process, machine, or composition of matter. First to file. Ever since 2013, the United States has been first to file. There is a 1-year grace period. So if you start selling your product that is covered, that embodies your invention, you have up to a year from the time you publish it or sell it in the US to then file your application. Now, some foreign countries have between 6 months to a 1-year grace period. Other foreign countries actually require absolute novelty, so that you have never published it, never sold it, never commercialized it in any manner before you filed it. And so the best practice is just don't publish it, don't commercialize it before you file it, so it keeps all of your options open. There's different types of patent applications. If you're not exactly sure what your final embodiment of your invention is going to be, provisionals are nice because they're inexpensive and they at least hold your place in line. So when you file those patent applications, they never get examined, but they just hold your place in line, which then within a year of which you can file your non-provisional patent application, which is what everybody normally thinks of as a patent application, which does get examined, and if it meets all the necessary criteria, issues as a patent. Design patent is another thing to keep in mind. If there's a certain look, an ornamental look or design of your patent, that's another way that's less expensive and a different way to go about protecting certain inventions. Now these last three, it's kind of an iterative process. I like the invention disclosure form because it helps inventors create a pathway of here's the problem we solve, here's how other people have done it, and here's how we do it and how it's different or better or faster or more efficient, more effective. Then your patent review board, which could be one person and your patent attorney, or it could be several people, look at all the different invention disclosure forms on a periodic basis, maybe once every 6 months, once a quarter, once a month. It just depends on your volume of inventions. To determine subject matter eligibility, your strategy, as I mentioned before, it has to match. So your IP strategy here, again, looking forward onto future releases of different products, this is a good time to incorporate that and deciding which inventions are we going to file patent applications on, which ones are we going to hold off for a while, and so on and so forth. And again, where are we going to get our best ROI on these dollars? And then once you have some prospective ideas, then you can do patent searches to decide, well, okay, this is a great idea. Let's do a patentability search. But if it comes back and it says, oh no, there's a lot of people that are doing something very similar, then you go back to the patent review board and say, okay, now with this information, is it worth it for us to put our money in because the scope of coverage could be very, very narrow, very easy to design around. That might not be worth your money. And then freedom to operate is just that, is that if you have some room, some capability to explore and innovate in different areas, the freedom to operate is a nice search because then it lets you know, hey, there's a lot of people over here, but over here there's not as many people that are innovating and creating, and there's a lot of wide open space. So let's focus our R&D in that area over there instead. Now this is new. This was just announced last month, this COVID-19 prioritized examination program. The goal is to reach final disposition, meaning they either give you a notice of allowance or a final rejection within 6 months, which is really fast because a lot of times, depending on the art unit at the patent office, you might not even hear a first response for up to like a couple years, depending on how impacted the art unit is. So to actually get a examination and a final disposition in that period is blazing fast. And that saves you about $2,000 because that's what it costs to normally jump to the front of the line. However, in order to qualify, your product or process has to be subject to FDA approval for use in the prevention and or treatment of COVID-19. So they are taking up to 500 qualifying applications. And as of last week, there were still 465 spots available. So, okay, trade secret is information that derives economic value because other people don't know it. But it also has to be information that is subject to your reasonable efforts to maintain its secrecy. Now, you don't have to be a superhero. You just have to, under the circumstances, do your best that is reasonable to keep that a secret from other people. Now, this can be any information. These are just a couple of examples, you know, formulas, customer lists, vendor lists. Also, I find it very interesting, negative information, meaning we did some experiments and we know 20 ways this thing does not work. That is trade secret because if someone else got a hold of that information, it saves them months and Lord knows how many dollars worth of R&D costs to jump ahead and leapfrog given that information. So NDAs, I know people love NDAs, especially inventors and founders of companies. And I know venture capital groups don't like NDAs and angel investors don't like them. So there's always a push-pull here. And so you have to really realize that NDAs, obviously it's great to have them if you can get them, but a lot of times you can't get them. So in those cases, I would say, try and create like a black box when you're doing your presentation to these potential investors and just say, and we've come up with a proprietary way of doing X, Y, and Z. And you can speak to the features, but not necessarily give away the secret sauce, right? Until you get farther into the relationship, if they really feel they need to know, hopefully you've built up enough goodwill, they're interested enough at that point, you can start tailoring the level of disclosure to the level of NDA you can have them sign. So with coronavirus, obviously a lot of our workforce has been displaced. And so where you may have had, just a small suite of executives working on company laptops via VPNs, now you have potentially a lot of people working from home versus via personal computers and devices. And the problem is you may have already had remote work rules in place for keeping trade secrets. But now there's problems with scaling and distribution. You might not have an extra 20 laptops laying around, all with the correct software to make sure that everybody's doing everything the right way. You also have new workers that aren't used to working remotely that may be jumping on public Wi-Fi at coffee shops, trying to access potentially trade secret information. So you need to really have those rules in place and explain them to people and train them on what's okay and what's not okay. Again, it's a blending IT and IP to prevent disclosure of trade secrets. And you might want to start, if you haven't already done so, consider carving up access to different parts of the system, different parts of data, and restricting them only to people that actually need them, make them password protected, things of that nature. Training, training, training. That's what I just mentioned right now, is that you have to have these policies in place and you have to tell people what's expected and then remind them every so often. So that way you're making those quote unquote reasonable efforts to maintain secrecy. Okay, now to trademark. This is where you have a brand name, a logo, a slogan, things of that nature, and it identifies the source of goods and services, and it should also be part of your business plan strategy to protect your branding. The brand hierarchy, that just means there may be different levels of branding. There may be the name of the company, there may be name of products, there may be internal logos and internal trademarks that you just use internally. So not every trademark needs to be, you don't need to apply for a registration on every single one. Future geographic markets, that one's key, because if you're going to apply for a trademark in another country, you really need to do that sooner rather than later, because unlike the United States, where you get trademark rights automatically just by use of a trademark, in a lot of other countries you don't. So it's all first to file over there. And so if you want to expand to another country and someone knows you're getting big, they may go ahead and file and squat on that trademark and then hold you hostage to try and get a lot of money out of you to buy it. Common law is what I just mentioned, when you just use it. And then federal registration is definitely preferred and gives nationwide notice of ownership. So this is the spectrum of trademarks. And so you ideally want to be in the top two, right? Fanciful is a made up name, essentially, a made up word. Arbitrary is just something that really doesn't make any sense of why you would use it in connection with a certain product or service. Suggestive is, it's protectable. But then once you get to descriptive and generic, it gets much more difficult to obtain a federal trademark registration because they don't grant those. So clearance search, this is key because it helps you reduce cost of just obtaining the registration. It also helps you eliminate risk of third-party claims that you're creating a likelihood of confusion with their brand, their logo, their slogan. Copyright, we just briefly touched on earlier, those are original works of authorship in a fixed tangible medium. That can be like source code, that is a work of authorship. Now these two are key, especially if you have a website or you have apps that you developed, is that it's really important to have these tailored by someone who knows what they're doing, because that sets the rules on how a user interacts with your software or your app, but also privacy policy. And that's big, especially in California. And even though it's a California law, it does have the ability to affect corporations, LLCs, other companies, even if they're somewhere else in the US. If that entity has at least 25 million in annual revenue, they receive, buy, sell, or share personal information on at least 50,000 California consumers, households, or devices, or they derive more than half of their annual revenue from the sale of personal information. So that's key. That just went into effect January 1 of this year. So that's very important as you're developing these things, to have somebody look those over and make sure you're in compliance. Data security, obviously it's important. We have a lot of data breaches these days, hackers, and so it's important to protect your customer data, your employee data, and business partners and vendors. You know, they all have sensitive information, and you want to make sure that you don't, you know, leave that wide open so someone else can easily come and get it. I mean, there are, you know, there is insurance for data breaches, but you don't ever want to use it. You really want to be known for protecting people's data, doing a good job, because it's hard to rebuild that goodwill if you don't do it right. Okay, so top common IP mistakes: not having the proper IP assignments in place right from the beginning. Again, best practice is that you disclose or otherwise sell potentially patentable material before filing your applications. Missing statutory bar deadlines. So if you do file a provisional patent application and you don't file your non-provisional within a year, you just missed out on that statutory bar deadline and you can't fix that. Not properly protecting trade secrets, we went over that. Adopting a trademark owned by someone else. That has happened to a client of mine. I gave them this presentation and told them that line, and then they actually went ahead and adopted a trademark someone else that was very similar to something someone else is using. And then they called me up a couple months later, almost in tears. But we worked through it, we got through it, but yeah, don't do that. It's very important to do a trademark search to make sure you're not stepping on anyone else's toes. Adopting a weak trademark. You can't, if you go into an area where, so that has two problems. Number one is it makes it difficult to get a registration if it's weak. But also is that if it's very commonly used, if the terms are very commonly used in your industry, you can't go in and start using those terms and then try and stop other people. If 20 other people are already using a very similar mark and you are allowed to get a federal trademark registration, you can't go back retroactively and stop those other people. And same, if you have a new competitor, you can't stop them from using something similar because, you know, 20 other people are already using something in the same vein. So it's good to try and use something as the spectrum we mentioned earlier, you know, something on the fanciful or arbitrary that's unique that not a lot of other people are using in that area. Publicly available material that is copyright protected. So as you're putting together your website or any other material, you definitely don't want to just grab photos off the internet. You want to make sure that you know, do it the right way, that you purchase the, you know, if you're using stock photos, you know, purchase them from a site, you know, pay whatever licensing fee is necessary and do it the right way. And then open source software. We did have a question about this. This is a very complicated area of law that I am not super well versed in. I would say you have to be very careful in exploring this topic because in some open source software licenses are much more restrictive, like GPL. Others have a little more wiggle room. And so I would say if you're gonna use open source, that might be better for, I'd say like prototyping, proof of concept, where you're not distributing the work to anyone else, just to see, you know, how does this work? maybe doing beta testing, experimenting with, you know, with different functionality, and then potentially hiring someone, or either as an employee or contractor, to then develop that functionality on your own, so you don't have open source software as a potential vulnerability as far as you know, having to start all over again if, you know, you get sued for breaching the license. And so there's different levels of restrictiveness on different open source software. I think there's about 6 to 8 different ones, and they all have something a little different. So if you do want to use open source software, find one that has a license that is something you can live with, or just don't use it at all unless it's functionality that's very basic and doesn't address what you're doing, like a shopping cart. Right? If you have a shopping cart on your website, that's fine to use open source, things like that. But once you start getting into you know, the functionality, I would highly recommend you talk to an attorney that is very well versed in this field, and make sure you're doing it the right way. All right. Well, I think that covers for now. I know I blazed right through, and let's open it up for questions, Aaron.
Yeah, so we have a question about how a trademark search is performed, and is it something you can do yourself?
Okay, let me go back in there. Oh, I took it out in the interest of time. Okay, so the trademark search, there's 2 different ways you do trademark searches. There's a knockout search, which that's pretty much you do a search on the trademark website, and just to see if there's anything that's someone's using similar to yours. You also do a Google search to see if there's other common law users that they might not be in the federal register, right, on the primary register. And so you do both of those, and so that a lot of times you can do on your own, just to knock out. If you have 3 or 4 or 5 ideas for potential trademarks you want to use, then you can do that knockout search, and you can do that on your own just to eliminate, oh wow, you know, there's 3 other people using something very similar, either with a common law search you would do on Google, or through the federal trademark registration database. Now, once you've done that, then you can go ahead and either hire an attorney or do it yourself, and pay for a full national search for the US. Most people just do that. And that would cover common law uses, domain name registrations, social media where people have used it on there, but also all 50 states. It covers their state registrations, federal registrations, and I think it also covers the Secretary of State for all 50 states to see what companies are using what names. And so that's the next level. The thing with trademark, I heard one time somebody say it is deceptively easy to mess up. And I have definitely found that to be the case. And so if you don't know what you're doing, I would definitely hire a professional to do the trademark search, at least past the knockout search, to interpret the results, because you can still order the search on your own. But if you haven't spent a lot of time applying for trademarks, you don't know which things may or may not be problematic for you.
So the next question is, can we add additional info to a patent application after the provisional?
Oh, good question.
If that additional, so it goes on. So if that additional info came from another inventor, can we then add that person's name to the application as well?
Okay, so if it's a provisional, as I was mentioning before, I do like using provisionals for if it's a product that's in development and you're not exactly sure how it's going to end up. You may have new developments, and so each time you add a new provisional, it can have new information, and it's a completely standalone entity. But you cannot go back and add information to that very first provisional. But it is what it is, and that's it. So if you say had elements A, B, and C in your first provisional, and then 3 months later, you have A, B, C, and D. When you go to file your patent application, it can have the disclosure of all A, B, C, and D, and it can have the new inventor that came up with D, but they will only have the benefit of the filing date of the second provisional that had D in it. They can't go back and claim priority to the date of A, B, and C.
Okay. Would you recommend doing 2 separate patents then in that case, or?
It depends.
Okay.
It depends. You know, I have some clients that like to pack a lot of inventions in one patent application. That really increased the cost. But I mean, there are benefits of both, right? Is that if you want to cover everything in one, it costs more to prepare it, but then you only have one filing fee. And if you're able to draft the claims appropriately, then the patent office may treat it as one application, and you can have just different variations. Other times, if the inventions are so different, then the patent office will issue what's known as a restriction requirement. And so you have to break it into multiple applications, and then multiple, filing fees and increased costs as far as maintenance fees going forward. So it really depends on how different each of the different things are that you disclosed in the provisional patent applications. If they're related enough, you can do it as one.
Okay. So someone's asking, how do you figure out if the combination of tech ideas as a combined thing is unique enough to be patentable? Especially if each part of the tech is in and of itself not particularly special.
Right, and that's a very good question. That is one of the heart of arguing essentially during patent prosecution, because you have the examiner, and the examiner looks at it and tries to, find each of the different elements of the claims that you set forth in your application, and they try and find references that disclose or teach or suggest each thing. And then sometimes, though, they misinterpret them, and you have to argue the subtle technical differences. Sometimes there are legal differences. Sometimes there's a lack of a motivation to combine, or combining those two references wouldn't make sense because it would render the first reference ineffective for its intended use, or change its principle of operation. So there's a lot of very nuanced arguments that you can set forth to show that, yes, it may have been known to do A, B, and C, but and even D, but it doesn't make sense to combine them the way the examiner, and in some cases the examiner is not allowed to combine them if it doesn't make sense to one of skill in the art.
Got it. So what are the ways to protect trade secrets when writing a patent for a piece of hardware that uses scientific knowledge that is not used by competitors?
Well, that's the rub, right? Is that there's a difference between trade secret and patent, in that patent, it's essentially a social contract, right? Yeah. Is that you're innovating and you are granted a right to exclude other people from using it for the term of the patent. But in consideration of that right to exclude, you're giving away the information, and you have to give up the information so that one of skill in the art could readily make and use what you're creating. So if they're talking about not disclosing that information at all, they can't. If they want a patent, they have to disclose it. However, they can request non-publication, because generally everything is published 18 months after it's filed. But as long as you're not going to file in foreign countries, you can request non-publication, and that way you can keep it closer to the vest a little bit longer. Now, the flip side is trade secret, is you don't have to give away any information, but then you run the risk of someone else independently developing it, or reverse engineering it if they get a hold of your device or product. So it's definitely something that you have to sit and think, okay, there's different times that each one is more valuable than the other. If it's very hard to reverse engineer, you know, and you think it'd be almost impossible for someone else to figure out or develop independently, that might be worth doing trade secret if you think you can keep it a secret, right? Another time trade secret might be better is if the life cycle of the product is really short, you know, and it's not going to build on itself, right? And so if you have a product that's going to be obsolete in a year, it might not make sense to file a patent application because then it's going to cost too much money and they're going to be on to the next thing. But if the next thing is using what you created as a foundation to build upon, then that still might be something worth considering. So there's a lot that goes into the analysis of deciding when do I give away my information, how much do I give away, and what form of protection do I want to use.
Right. So someone's asking how long the process time is for the U.S. trademark applications processing through the USPTO office right now.
For a trademark?
Yeah.
It depends. That's a typical lawyer answer. It depends.
Great.
So if you apply for a trademark and you do a really thorough search and the examiner has no problem with it, you can be through in, I'd say, 4 to 6 months. But if you either get an examiner that's digging their heels in and maybe you didn't do a very good search and so you're really close to someone else's mark, you may have to argue with them back and forth in different, you know, in response to their refusals to obtain a trademark. And even then, there's no guarantee. The nice thing about trademark, though, is that when you apply, you don't actually currently have to be using the mark. You can apply and have it be what's known as an intent to use application. And when you file that with the trademark office, it automatically holds your place in line and lets everybody know on a national level, hey, we intend to use this. And as long as no one else has been using it in common law prior to you, then that holds your place in line.
Got it. We've got a couple questions about costs. So how much does filing a provisional and a non-provisional trademark cost? And then how much in general should you expect to spend on legal fees to carry out kind of that process and application?
Oh, for patents? Okay. So I'm going to be thinking in terms of a small entity, right? There's large entity cost, there's small entity cost, and then there's micro entity costs. In general, most startups are going to be in the small entity category. And so to file a provisional patent application, if you were to do it on your own, so a client, you know, someone could take their invention disclosure form and file that on their own as a provisional patent for $140. So it's very cost effective to at least hold your place in line, maybe while you're still developing your product, maybe while you're raising funds. And then once you raise funds, then you can go back and file your non-provisional patent application that claims priority to the provisional, one or more provisionals you filed within 12 months before that. The cost associated with filing the non-provisional for a small entity, and again, there's a lot of costs that change depending on the application. So we had talked earlier as far as how many inventions can you kind of put into one. Well, if you're trying to cover a lot of inventions in one application, you're going to have a lot of claims. And so they allow you for one filing fee, an exam fee, and search fee, up to 20 claims with no more than 3 independent claims. Now, once you start going above those independent claims, once you start going above 20 overall total claims, then they start charging you per extra fee, or per extra claim, per extra independent claim. If your application is, I think it's over, I think they have a size fee. If your application is too long and too big, then they charge you a fee for that. So we're not talking about any of those extra fees. It's about $800, just if you stay within the normal limits of what they're requesting as far as the filing, it's about $800. Again, that's if you file it by yourself. If you hire a patent attorney or a patent agent, you can, you know, then the fees are going to depend on what they charge. In general, I try and tell my clients from soup to nuts, everything in from the time they file the patent application to the time that they have it issued, to budget, anywhere from $20,000 to $25,000. Now, a lot of times we can come in underneath that, right? And then once it issues, you still have maintenance fees that you pay to the patent office. But that's a ballpark, so that way, I try and aim high on that number so that people don't get the concept that it's super, super cheap, because sometimes it can be half of that, but I don't like to promise that. I like to aim high so that way people are pleasantly surprised. Oh, it didn't cost that much, rather than the opposite. Oh, and just so you know, those costs aren't all incurred at one time. The 20 to 25,000. Usually filing the patent application, depending on the complexity and how many inventions are in it, on the low end, 7,500 to 10,000 to file is kind of a ballpark. And then you have almost always, invariably, you're going to get rejections from the patent office. So you have to address those. And sometimes you have to go back and forth several times and appeal and whatnot. And that's where the additional costs come into play.
A quick one, how do you renew a provisional patent act?
You don't.
You can't. You just refile.
You don't refile it. You file the provisional, and all it is hold your place. And so once 12 months are up, that it's dead in the water. And so if you filed a non-provisional within 12 months of that original filing, then you can claim priority back to it, but you can't ever do anything with it or renew it or start over again. The clock starts ticking as soon as you file that provisional.
We've got some foreign questions.
Okay.
Is there a good barometer or metric for deciding when to apply for trademarks in other countries, like a rule of thumb? Someone's interested in expanding to Canada or the EU, and they're not sure how prevalent this trademark hijacking is in those countries.
That's a good question. I think it would depend country to country how long the process is, because it's different in each country how long it would take. But I would tend to err on the side of caution. And if you think you're headed in that direction, file sooner rather than later, because since it is first to file, it's a race to the office. And that way, worst case scenario is you file and then you decide not to keep the trademark, right? But I would imagine that would be much less expensive than if you're being held hostage to get the trademark you really want. I doubt it would be less expensive to pay whatever it is to buy the trademark from them than it would be just to file the application and pay the filing fee.
So who owns the IP if you're working with a foreign ODM vendor?
Okay, so that's, wow.
And then they're like, as in, the vendor has base hardware, but we add unique functionality and hardware design. So can they patent the parts that they made?
I would say yes, but they are probably going to have to, if they're building on someone else's IP, they would probably have to pay some form of licensing or royalty to use that IP as a foundation for their new creation. I would imagine that's how it would be structured. I mean, I think it would really depend on the nature of the agreement with ODM.
Yeah. When writing a patent that includes what you would rather be a trade secret, but for the decades-long lifetime of your hardware, can you use obscure language, like plain English, without using the scientific definition of words? Does obscuring wording methods are they still accepted by the patent office?
Well,
is that the way around kind of fudging those trade secrets?
I would say that's definitely a gray area, because yeah, it has to be enabling. That's what they call it, There's an enablement requirement that someone of skill in the art has to be able to pick up the patent and look at it and read it and say, oh, I know how to make and use this based on this disclosure. So as long as that requirement is met, that's fine. But if you hide the ball and intentionally don't make it enabling, then, you know, and someone came along and picked it up and said, hey, this is great, this sounds fantastic, but there's some missing pieces and I don't know how to make and use this, you know, and of course it's one of skill in the art. So that's a legal term that isn't always easy to define, but someone who's skilled in the art in which your invention pertains to that technology, that field, someone who's skilled in that field, if they pick up your application and couldn't decipher what's your secret sauce, what do you do, then it's not enabling and you run the risk of either A, not getting the patent, or B, not having it be, if you ever were trying to enforce it, if that ever came up during litigation, that could render the patent invalid and unenforceable.
Got it. So how many times can you refile a non-provisional utility patent?
Well, you can only file it one time.
Okay.
But what you can do, and there are some clients that like to do this, is if they put a lot of different inventions in to one application and they either get a restriction requirement, so they got their application split into like 2 or 3 different applications, then each one of those is treated as a separate application that claims priority back to the original filing. But some clients actually, what they like to do is keep a continuation, always keep one continuation application going that claims back priority to the original application. And they do that for a very strategic reason, is that if a competitor begins to get a little too close to what their technology that they've patented, but it doesn't exactly read on the claims as written and as issued, then they will use that continuation application to now craft claims that are directly aimed at the competitors' products or service products. Mm-hmm. And that way, if they can get those issued, then they can either, you know, use that as leverage for either getting a licensing or royalty situation, or to get them to get out of that space and change their product so that's no longer competition.
Good. We got a question about which foreign countries do not require absolute novelty for a patent application?
I'd have to look that up. Okay. I don't, right off the top of my head, the list is very different and I haven't memorized those.
Got it. What date of invention is possible if the invention took 6 years to get finalized? I've heard 1 to 2 years is all the PTO will accept. Can the provisional include dates of each major step? Can the final? Then the time to market exposing the IP might be 4 years. So what would the PTO date be?
The day you file.
It's just that.
It's the day you file. We used to be first to invent. We used to be until March of 2013. And so it used to be that you could have a date of conception where you conceived of the idea and the date that you reduced it to practice. And as long as you showed diligence all along the way, that was good enough. But that changed. And now ever since March of 2013, it's first to file. So you could work on it for 20 years, but you're only getting credit from the day you file the application.
We got from your sophomore year when you heard about IP from your roommate to the time you decided to go to law school, what were some experiences that helped you decided that you wanted to pursue IP?
I did my own personal research on the unique combination of law and engineering. Based on economics, I wanted to do something and be in a position where I was rare. You know, anytime you can make yourself rare and have a unique skill set, not many, I think last time I checked, there's only about 20,000 patent attorneys in the US. And that's a pretty small number, a number of people that can understand the technical details of an invention, but also the abstract ambiguity of law and the gray areas and play in both playgrounds. And so I also did an informational interview with a patent attorney, and listening to his explanation of what he did and his day-to-day, what was a typical day in the life, I thought, what, this sounds really interesting. And if I go into law and I don't want to be a patent attorney, that's fine. I can do other, there's a lot of things you can do with a law degree. And so I thought, what, this is definitely something I want to pursue because I have a lot of flexibility what I do afterwards. It just happened to be that I really liked patent law, IP in general. When I was in law school, I took all of the IP classes that my law school had to offer, and I loved them all. So that was kind of my path.
Would you say your engineering background helps you with patent law, or does it make you unique? Do a lot of patent lawyers have engineering backgrounds?
Almost all of us have engineering backgrounds, but I mean, it's anything that's a hard science. So if you have a hard science background, obviously including engineering, then you can do IP. Well, you can sit for the patent bar. And so I'd say it's a requirement. One thing that definitely helped me is when the dot-com bubble burst in 2001, a lot of the attorneys at my law firm got let go. And even though I had only been there about a year, 2 years maybe, when all of it started happening and everybody was getting let go, they let go about a third of all the attorneys in our firm. But they kept me. And part of the reason they kept me was because of the fact that I could do a lot of different things because of my engineering background from Harvey Mudd. If I was just a chemical engineer, just an electrical engineer, things of that nature, those were people that if they were more junior got let go. But since I could do so many different things because I had been exposed to so many different types of engineering at Harvey Mudd, it made me flexible enough that I could address a lot of different client needs and technologies, and that really served me well, I think, in weathering that storm.
Great. And someone generally asks what sorts of things you've helped get patented. Kind of just like some, do you have an area of specifics, or you're kind of all over?
Well, I would say the last 12 years, most of what I've worked on is cell phone technology for Kyocera. A lot of cell phone inventions as far as, ways to make the cell phone communicate better with other devices, with the base stations, with other, cars. Early in my career, I did a lot for Intel. Let's see, I've done some semiconductor fabrication techniques and devices. I guess my one claim to fame would be that I don't know if you remember Octomom,
Sure.
but I wrote the patent for the doctor that using his IVF for fertility treatment, he was able to have her have 8 babies. And so when I saw him on the news, I was like, that name sounds familiar, because it was years later, and it just happened to be that I wrote the patent, and it worked. So.
Yeah, is he getting a lot of use out of that patent right now? Because I
don't know. I think he may have been had his medical license pulled, but I'm not sure. I don't remember.
That's an odd claim to fame, but that's fun. All right, we're just about out of time. So I want to thank our speaker today. Thank you, Raul, for sharing your knowledge with us. Sure. Thank you to our audience for questions. We only had a couple left over. We got through most of them. And we will follow up within the next week with the video and the presentation materials and any additional answers we can give. Next up in our Mud Talk series is the new core and revision process with Professors Tom Donnelly, Catherine Van Hoevelen, and Ron Liebeskinta-Das next Wednesday, July 1st. Also coming up this week, we have 2 presentations hosted by our Summer Research and Scholarship Program. More details are on our website. And finally, I want to offer a word of thanks to all those joining in who have supported our HMC Community Emergency Aid Fund. To date, we've raised over $318,000 in gifts and pledges that will help to support our community during these uncertain times. And you can find all additional information about everything I've mentioned in our online offerings page using the link included in your registration email and at alumni.hmc.edu and clicking online offerings. So thank you everybody for joining us. Have a great day. Thanks, Raul.
All right, thank you. Thank you, everyone. Stay safe, stay healthy.
Bye.